So the first bill to discuss is LB15. LB15 is with regards to guardian ad litem changes in the statutes. In this bill, these changes do go into effect immediately. What LB15 requires is that by July 1st of 2015, the Supreme Court must provide by court rules standards for guardian ad litems for juveniles in juvenile court proceedings. Previously, the Supreme Court had entered guidelines for guardian ad litems, but by July 1st, they now must be made rules. Second thing that this bill did is it requires that the guardian ad litem must meet with the juvenile in his or her respective placement within 2 weeks of appointment and every 6 months thereafter, unless the court approves another mode of consultation. These must be in person, these meetings, unless it's prohibited or impractical because of exceptional circumstances. One of those discussed in the statute is geographical distances. There is a provision that the guardian ad litem can meet with their ward by telephone or other electronic means if the juvenile is of sufficient age and has a capacity to participate by that form of communication. If there is no feasible means, the statute requires that the guardian ad litem must seek direction from the court as to any other acceptable method. Third thing that this bill did is it requires the guardian ad litem must submit written reports and recommendations for every dispositional, review, and permanency planning hearing. This report must contain the type and number of contacts with the juvenile, the type and number of contacts with other people, and the type of contacts with other court personnel. There is to be a form that is completed by and prepared by the Supreme Court that is to be used by guardian ad litems. Fourth thing that this bill did, which will directly impact the Foster Care Review Office, is that a copy of the guardian ad litem's report and recommendations must be submitted to the Foster Care Review Office for any juvenile in out-of-home care. Last thing that it does is that guardian ad litems must submit an itemized bill that is signed by the attorney for each and every youth that they are a guardian ad litem for. Even if they are a contract type of guardian ad litem for the county, they still must submit itemized bills so that we're able to see exactly what work was done. Those are the major changes to LB 15 with regards to guardian ad litems. We are currently working with the Supreme Court and with guardian ad litems to come up with the best process in order to ensure that we receive copies of all the relevant and needed reports.